The European Court of Human Rights is allowing the South African Human Rights Commission to intervene as a third party in Caster Semenya's challenge to regulations that prevent her from competing internationally. Commissioner with the South African Human Rights Commission, Advocate Hurtley Gaum, joins us to take a look at the story. Firstly, Advocate Gaum, what does it mean for the HRC to be admitted as a party in this case?
Good evening. Yes, we had to apply for the intervention, and we are delighted that the court has allowed the Commission to intervene. This is the very first time that the Commission is involved in human rights litigation in an international forum, and it's also the first known occasion that the European Court of Human Rights has granted leave to intervene to an African human rights institution. But more importantly, this is about one of the, if not the most important gender equality cases in history. And therefore it is indeed a privilege for us, because this is not only about Caster Semenya, it is also about what is alleged to be discrimination against women, in particular black women from the global south. So Ms. Semenya's challenge is grounded in various rights enshrined in the European Convention of Human Rights, and the South African Human Rights Commission sought leave to intervene in the matter so as to elucidate the adverse impacts of world athletics differences of sex development regulations on women from the global south. In particular, the Commission wishes to make submissions to the European Court of Human Rights which demonstrate the discriminatory effect of the regulations on the intersecting grounds of race, gender and sex, and which further show how the impugned regulations breach Article 14, that is the article of the European Convention of Human Rights dealing with the prohibition of discrimination, in conjunction also with Article 8, the right to respect for private and family life, and or Article 3, the prohibition of torture, all provisions of the European Convention of Human Rights.
So when we look at the scope of the intervention, I mean, have you been given certain parameters within which you'll be able to make your argument?
Yeah, the South African Human Rights Commission has been granted leave to make submissions to the European Court of Human Rights by 12 October 2021. So that is around the corner, but still gives us enough time for our submission to the court.
And in terms of the actual case itself, are there specific issues that you'll be allowed to argue, or can you go for any part of the case that you feel is appropriate for you to deal with?
Yes, I think I've indicated now the scope of our intervention and what exactly we are going to deal with. We had to make out a case before the court that we have a unique contribution to make, and I believe we were indeed able to do so. It is quite important also to mention that in our submission to the court for intervention, we pointed out that in evaluating the claim for violations of Article 14, that is the anti-discrimination provision of the European Convention, in conjunction with Articles 8 and or 3, the court will need to understand the context of a black woman from the global south, and also adopt an intersectional analysis on the grounds of sex, race and gender identity. And we pointed out to the court that the South African Human Rights Commission has expertise in this regard. It has been instrumental in building and working with a body of jurisprudence in our country that analyzes the meaning of non-discrimination, equality and dignity from an intersectional perspective. We pointed out to the court that the founding values of our Constitution inter alia relate to human dignity and equality, and that the development of our own Constitution was also influenced by the European Convention on Human Rights, and that therefore, and for other reasons that we pointed out, it is indeed the case that the Commission is uniquely placed to intervene in this particular case.
one of the trials that was conducted and that formed the basis of the IAAF in making the decision that they did against Caster Semenya was around the link between testosterone and how it affects athletic performance. That study has been largely discredited very recently. Will you be using it at all in your case?
Well, we'll have to further consult on that with our legal representatives. And as you might have seen, we have a formidable legal team led by one of our own South Africans, Jeremy Gauntlet, SC, QC, is also a QC, so he can appear in the European Court of Human Rights. And Baker McKenzie, that our attorneys and various lawyers, including advocates and attorneys, both from South Africa, London, and Paris. But it is certainly something that I think we would be able to advance, given the scope that we have indicated to the European Court of Human Rights that we will be dealing with.
Advocate Hurtley Gaum from the South African Human Rights Commission. Let's leave it there for tonight. Thank you so much for your time.